Hello and welcome to the estate planning what you need to know presentation. So this week is actually estate planning awareness week. And while that's kind of structured badly for the tax deadline, we did manage to pull this together and put together what we think that you all need to know, both to help us and learn about us, but also in your own life and your own estate planning. So we actually have a couple goals for this presentation. One is to introduce ourselves as the niche committee here. Second is to inform you about our niche and what we do and the type of services that we provide that can also help your clients and yourself. And third, we want to give you information that you can use in your own life. So those are our three goals for this presentation. First, mostly just introduce ourselves. So the head of our trust and estate committee is Cindy. She manages everything. Everything goes through her. The workflow is always goes through her, and then she kind of designates it out. We also have Todd and Cheryl. And I kind of call them the knowledgeable consults. You know, they know a lot about the area. We use them as we need to. We come to them with a lot of questions. And also we have 3 staff that we are preparing returns and such, and we work under Cindy, and that's me and Chris K and CJ. We also have Kim as our admin for our niche. She does a lot of the marketing. She helped put this together. And so these are the people that you'll go to if you have questions, or if we have that type of work for your own clients. We perform kind of 3 different services. Obviously, we do tax compliance. We're a CPA firm. We do a lot of that. So that's kind of what most of our focus is on. We prepare the returns. But I would say that this niche kind of has a little bit more consultation and guidance than average. So people get used to filing 1040s their whole life, right? But when someone passes away and there's new stuff, we kind of have to handhold them through. They don't exactly know what's due. There's different kinds of steps. We do a little bit more of that work. I also included estate planning on here. Although I will say we tend to do more work on the back end. So if somebody comes and says, look, I want to look into kind of trusts, I want to start a trust, we might be able to have that conversation, but typically we'll point them to a lawyer who will actually draft the trust documents. So while we might be involved in some planning, especially like on the partner end, so since we're a full service CPA firm, we follow people through their whole life, right? We'll do 1040s for them, we'll do their business. Sometimes we'll also help them with that estate planning. So where do we start? Oftentimes somebody will come in and say, someone has passed away. That's the starting point. What do we do? Well, on the tax compliance side of things, we've got the final 1040, right? They've passed away. They can no longer file their tax return that needs to get filed. Therefore, the executor needs to file on their behalf. This return isn't very different than a regular 1040 that we've all prepared. Some of you may have even prepared deceased client 1040s, but ultimately it's just all income up until that date of death needs to be reported on a 1040. Easy enough. Then things stray a little bit with form 1041. People aren't as familiar with this. This is an income tax form, just like the 1040, but for an estate or for a trust. Any income after death that's earned before all of the assets are distributed to the beneficiaries, that needs to be reported on a 1041. It's a little different than a 1040. You can do calendar year. For example, if somebody dies right in this middle of the year, July 15th, you can elect to do a calendar year and just file through the end of the year, or you can do what's called a fiscal year. And so you can make your year be right as of your date of death through the next, through the full year to the next month, right? So if you died July 15th, the year would be July 15th through June of the next year. That's what a fiscal year is, which does give us a little bit more time to compile everything and let the estate kind of go through. And that's 1 year of income. So those are your income tax forms that we need to file if somebody's passed away, right? Then there's a totally separate tax called the estate tax. And that's what we'll discuss a little bit more of today. Filed on form 706. And ultimately, if the gross estate is over 3 million in Minnesota, then we need to file. What is that 3 million? That's the lifetime exclusion for Minnesota. So if you die and the value of all of your assets is less than 3 million, you don't need to worry about this type of filing at all. For federal, it's 11.7 million, so it's a lot higher. So in Minnesota, we do have to keep track of that lower number. And it's just like normal taxes. So there's income tax that's computed on income, sales tax on sales. The estate tax is computed on the value of all of your assets as of the date of death.
I got a game for you guys. Well, it's a question. It's a puzzle. It's a task. And the audience can participate.
Okay. Meanwhile, while we're trying to do all of these tax filings and such, The executor, who needs to work with us, is dealing with a lot. They're often grieving the death of a loved one. There's the forensics of trying to find everything. They may have not been very close to this person. They need to find every asset and every source of income and details on all this. Sometimes they can't even get access to these assets. Even when they find them, they even walk into the bank with all the proper documentation. They might not have access for a while. That can be very stressful. And bills are coming in from who knows where. They don't know whether to pay these bills or whether they should try and get the service stopped. We're not the only one that they're hiring. They might need to hire a lawyer for probate, so they need to find the right lawyer. And also there's stressors coming from beneficiaries. If they're a little bit slow on finishing the estate, their family members could say, hey, where's my money? I know that I'm owed this money. This is all weighing heavy on the executor. And finally, if they had a longtime family accountant, that accountant might say, sorry, I don't do estate tax. I can't help you. This is a trusted advisor that can no longer help them. So we're dealing with all these estate tax filings, but with the executor dealing with a lot. So let's go back to estate tax in general. And the lifetime exemption is 11.7 million for federal and 3 million for Minnesota. You might have been thinking as I was saying that, look, if they're going to tax me on the value of my estate, why don't I just make sure I give away all my estate before I die? That'd be clever, but the government already thought about that. And that's why gift tax is also a thing for the federal government. If you do try and give away your assets, you need to file a gift tax return. Now, gift tax and estate taxes are essentially the same concept on the federal level, where if you are giving away your assets, that goes against that lifetime exemption, right? So you can think of it as lifetime gifting, lifetime transfers. So if you're giving away your assets, that goes against your exemption. There is an annual exclusion. So if you give under that, you don't need to worry about gifts. That's $16,000 for an individual or $32,000 married filing joint. But any amount over that. So if I gave $16,001 here to Chris Burtz, I have a tax filing requirement. So does Minnesota have gift tax? Actually, Minnesota deals with that issue a little bit differently. There is no gift tax for Minnesota. So you think, well, how do they avoid people just giving everything away for their estate? Well, Minnesota actually has what I would call a 3-year clawback. So if you give away your assets, but you die within 3 years, Minnesota is going to pull those assets back into the estate. So you might actually have to go to those people who received those gifts and say, sorry, this is now being taxed. And so that's a different way that the federal government handles gifting in the state versus Minnesota. These are the estate tax rates, just so that you can be a little bit familiar with them. Pretty similar to other tax rates. We've got the federal rate starts at 18%, and it steadily goes up very slowly up to 40%. Everything over 1 million is taxed at 40%. So it's pretty significant over that. Once you get over that 11 million exemption, or 22 if you're married, then it can rack up real quick. Minnesota actually starts you at 13% all the way up to 7 million, and then slowly goes up to 16%. So it's pretty slow raise there, but also they have a much lower exclusion. So remember that. So I'm going to briefly go over trusts and the concept of them, since this is a estate and trust niche. But my goal here is just to get a very broad overview of how these taxes work, right? So a trust is essentially a separate legal entity that you can set up and you can also transfer assets to. And there are several different reasons people would want to set up a trust. Oftentimes, this is to protect assets from creditors, protect assets from an irresponsible party they don't want access to have the money to. You can also make transferring assets easier than other methods like probate. So when you die, it's easier to transfer these assets. You can maintain some level of control over gifting through a trust. You can also designate specific long-term goals for your assets. For example, if you want to provide long-term support for either a charity or an individual. And importantly, trusts can be used to remove assets from your estate. So if you gift early on into a trust, then all that growth is not part of your estate. You can get assets out of your estate, and that's kind of the planning mechanism that we can use to get away from estate tax. I like to think of trusts as in 2 buckets. Now, this is not a hard and fast rule at all, but essentially, trusts are set up as based on finality, right? Is how I'm going to describe it. We have trusts that affect taxes and trusts that do not affect taxes. So in general, trusts that don't affect taxes are often revocable. So you can just revoke the trust and say, never mind, I disagree, I changed all my mind. They tend to be in the grantor's social security number. And that's one way that we know that it's generally taxed straight to the individual. So if I set up a trust and I put it in my social security number and I maintain a lot of rights. So I maintain the right to switch assets out of the trust at my will. I maintain the right to switch beneficiaries and decide who it's going to. I maintain the right to nullify or amend or do anything. Then ultimately, that often does not affect our taxes, either our income taxes or our state taxes. That trust is just mine and everything comes to me. It's a little bit like on the business side when you look at a disregarded entity, right? Then we have trusts that do affect our taxes. These are more final, right? These are irrevocable. You actually lose access to it after you finalize it. They tend to have a totally separate FEIN. And so all the assets are placed into that. And these are completed gifts. You can't pull that back. Once you've signed it, it's gone. Any rights that you'd maintain are minimal and of little consequence. And these are generally the types of trusts. There are tons of types of trusts that maintain various different levels of control. I'm just trying to get you the groundwork of kind of whether they do or do not affect our taxes, right? So if you do run into trusts, it's not a bad idea to run them back somebody from our niche. But in general, this is why they do not affect your taxes. And now I'm going to pass it on so we can discuss a couple other concepts that you can use for your estate planning.
Well, sticking with the planning portion for your estate, we're going to continue talking about things you can do. For instance, power of attorney. You can have someone become your agent as a power of attorney. It's a legal document. You go to a lawyer, you can have them write it up for you. They control, not really control, they can help you with your financial activities, buying, selling assets, just anything really that you would need their help with, your power of attorney can help you with. There are different types of power of attorney. Limited, which would be your power of attorney has limited powers of what they can and cannot do. And then general is just, they can do it all. With all of this power, you might be wondering why you would want to give someone this power. It really comes down to three main categories. The first being convenience. If you do not want to go somewhere to sign a document, your power of attorney can do it for you. If you are traveling, say you were going to Arizona for the winter, and you have a business deal in Minnesota, so you don't have to travel all the way back. If your power of attorney is in Minnesota, they can sign the document for you. They can work on bank information for you. And then the main reason we see power of attorneys being given their power is through accidents or illness. If you become unable to help yourself financially or make decisions for yourself, your power of attorney can step in and help you make your decisions without having to run into the roadblocks of you not being able to do anything. A lot of the times when I worked at a credit union, we would see someone being stuck in a nursing home with no power of attorney. They would have no way to access their money, no way to sign documents unless a notary would go to the nursing home so they could have them notarize things. This is an easier way around stuff like that. If you don't have a power of attorney and something happens, you could be stuck. Otherwise, the court can appoint one to you. You don't necessarily get to say exactly who that is. So it's better to just appoint one yourself if you think you might need one, than have the court do it for you. The main thing with power of attorney, though, it is void on death. Moving to a will, we're going to start with what happens if you don't have a will. If you pass away and you don't have a will, your estate cannot go to charities, it cannot go to your friends, it cannot move certain items to certain people. Then you do not get to pick who your executor or personal rep of your estate is. The court will appoint one to you. It also makes the probate process a lot harder, it takes a lot more time than if you would just have. What a will does, it will distribute your assets how you want them distributed. You will also appoint your personal rep in your will. And then that personal rep, like we talked earlier, will be responsible for the distribution of your estate, the taking care of your 1040, the 1041, getting everything filed and all of that. If you have a will, your estate still goes through probate. The process is just simpler. The one thing that the power of attorney cannot do that I should have mentioned earlier is they can't change your will. But what they can do is change the ownership of your assets, which could have a big impact on your estate. But for you to change your will, you have to change your will. The one thing one thing that supersedes your will is beneficiaries transferable on death accounts, stuff like that. Those will always be taken care of before your will. So it is important to always have those accounts updated with your will as well. Now we're going to talk about probate. It's titled Simple Probate. We'll get into that. Probate, when you pass away, your will go through a verification process. They will authenticate your will, make sure that your personal representative is in a state where they can be your personal representative. Then they will value all of your assets, gather them all together, pay off the debts, and then they will distribute your assets either by your will or how the government sees fit, which is normally to your significant other, your spouse, your kids, then it's your parents, and then your siblings. Simple probate is if your estate in Minnesota values less, $75,000 or less. In Wisconsin, it is $50,000 or less. You can have a document filled out with the value of the estate and the assets. It is notarized, and then after a 30-day waiting period from the time of death, those assets can be transferred to the person who filled out the document. It has to be, in most cases, your significant other or your next of kin. Estate is special. If you have any single owned real estate, your estate has to go through probate. The only way really around this is if, for instance, you live in Minnesota and you have a transferable on death deed to your house, then on death, your real estate will transfer to a new owner. Beneficiary versus transferable on death are a little bit different. They are not the same thing. Your beneficiary receives the value of the asset. So if you have a bank account and you have a beneficiary, they will receive the money in the account, not the account itself. Whereas if you have transferable on death, they will receive the account itself and everything that goes with it. You'll commonly see beneficiaries on bank accounts, IRAs, and then transferable on death. You see that more on real estate. Sometimes you even see it. Lost that asset. And then the only way to really avoid probate altogether would be if you had a living trust and you had all of your assets in your trust ready to go before you died. That is really the only way to avoid it. Although probate is not this big scary thing, it just could take a while if you aren't prepared. That being said, I'm going to pass it over to Chris K so he can finish out our presentation.
Great. So they kind of went over the JK part of the process. We kind of went over a lot of the tools that are used during this process. I'm going to take a higher view, and we're going to kind of go over like more the importance of estate planning and why people will even begin to start the process, right? So when you start the estate planning process, when you go to an attorney, when you start trying to figure out what you want your end goals to look like, one of the first things they're going to ask you is like, what is most important to you, right? When this process is complete, like, what do you want to see as the end result, right? So like, what do you want to happen even like, say, when you're still alive? And that's where like the power of attorney comes into play. Like, who do you want managing your finances when you're incapacitated? Who do you want making those medical decisions, right? Who's on your healthcare directive? Do you need your spouse to be taken care of, let's say when you're incapacitated via a trust while you're still alive? When one of your spouses pass away, right? What do you want to happen to your spouse? Do you want to have them, are they able to, a lot of times one person takes care of the finances, or the other person, say you pass away, are they able to take over for you, right? A lot of this planning can be done ahead of time. And like, what happens when you both pass away, right? Where do you ultimately want your home to go? How do you ultimately want your assets split up? Right, so I'm going to kind of go over some common objectives that people have when they start preparing their estate planning. Kind of a general one, but a lot of times it's just kind of for a general peace of mind, right? They know they're supposed to do this. They know that they want to make it easier for their spouse. They know they want to protect their children. They just really wanted to make it go as smoothly as possible, right? We kind of went over a lot of the tools that people use to complete these objectives. The power of attorney, healthcare directives. Sometimes if you have specific situations, you'll be doing a revocable trust, maybe wills. A shameless plug here is When I'm Gone handbook. I mean, how many of you, like some of you are younger, but some of you will be handling like your parents' estate, right? Like, do you know like where the titles for their home is, right? Do you know where they bank? Do you know where like their investments are? A lot of this stuff, like one of the biggest burdens that like Jonathan had mentioned is just trying to retrieve all of this information when someone passes away. Like a lot of times you have no idea what your parents or the people that you're put in charge of taking care of, like where their assets are. And the book that's kind of in front of you has a lot of that. It allows you to have a lot of that information in one place. So when someone actually does need it, like it's there for them. It takes a very big burden off of their shoulders. So. Well, one of the common objectives, other than just kind of a general peace of mind, right, is you want to protect your spouse. And this can kind of be broken into two pieces, right? So again, like a lot of times traditional families will have like one person taking care of the finances, one person will take care of other pieces of your family, right? Well, when you pass away, a lot of families don't commingle funds, right? Do you both have separate bank accounts? If one of you passes away and they're typically the one that pays a lot of the bills, that account could get frozen if it goes to probate, right? That could be months before you have access to that money. Is the other person going to have enough money to kind of, pay the mortgage, pay the utilities until that money becomes unfrozen? Beneficiary designations kind of help with this too. The money kind of gets immediately transferred over. Trusts can also help with this piece. The other side of it is more like long-term, right? So after the initial funeral costs are paid off, a lot of these immediate problems are taken care of. Like, how do you want your spouse to be taken care of? Maybe you really want your money to go to your child, right? But you can set up a marital trust. You could have them take like a monthly distribution every month. And then once they pass away, right? Then they can actually go to your child. So there are multiple ways you can do some of this stuff. The other one is I want to protect my children. You'll hear this a lot. There are multiple ways to do this as well, right? You can keep them. You can just straight up leave it to them outright, right? Maybe your children are older, they're 40 years old, they're responsible. Like when I pass away, we're going to split it 3 ways and it's just going to be done with. They can do with the money what they want. Other ways to leave it to them would be like in a trust. Maybe they're a minor, right? Maybe they're 20. You definitely don't want to give them, $100,000 right off the bat. So maybe you give it to them in thirds. You can give it like a third when they're 25. You can give it to them a third when they're 35. You can give the last piece when they're 45. Sometimes people maybe they're poor with money, right? And you want to make sure they're taken care of, but maybe you want just enough for them to have, be able to pay the rent, have enough for utilities and food, and you can just give them a monthly distribution. There are plenty of ways, and a lot of times you'll see trusts come into this. There's just so many ways that you can handle your estate planning problems with trusts that you'll see them quite often. On kind of the inverse side of that, maybe you want to disinherit someone, right? Don't like your son-in-law, right? And you just really, like, you're worried about, so like, say if you gift your money outright to, say, your daughter, right? Those funds are going to get commingled in the marriage. When there's a divorce, well, that inheritance is going to get split between the two, right? And this doesn't even have to deal with like you really don't like them. Maybe you just really want that money staying in the family, right? So maybe you're going to put the money into a trust in her name, and that way, whether it goes for better, for worse, the money always stays in the family. Another piece is just like maybe a protection from like a spouse, I guess when a spouse remarries, right? Say you give your money to, all of your money goes to your spouse, right? She gets remarried. Well, if she passes away, that all that money goes to the new husband, right? Sometimes it's better to put it into a trust. That way she'll be taken care of. She'll have access to it. But when she passes away, the money can ultimately go back to your children. This is more of an issue with like blended families, right? When there's kids from a prior marriage, and you want to make sure that everyone's taken care of. So. Another reason you'll see for people that want to initiate this process is they really just want the right people in charge of their estate when they die. I mean, for as a personal example, for the healthcare directive, my dad 100% did not want my sister on his healthcare directive. She would have kept him alive indefinitely. Like every penny spent. Like my dad is like, do not resuscitate. Like I only want to be here as long as I have to be. Right. So he put my brother on his healthcare directive. He didn't even put my mother as first. He wanted my brother as the first healthcare directive person because he wants the plug pulled. If he has to get any kind of tube in him, he wants out. Whereas like my mom is almost the exact opposite. She wants my sister on it, but she wants to live as long as possible. It's like every penny needs to be spent on my care right before you guys get a dime. I'm on the power of attorney. That's more because my dad's terrible with money. And once my mom goes, then. A lot of times people come in to set up their estate planning because there's just a unique situation they have, right? Whether it's like a disabled child, you want to set up a trust for to make sure they're taken care of both when you are alive and when you pass away. Right? Maybe there's, I mean, we are in Minnesota and our neighbors, Wisconsin, right? Maybe there's like a chemical dependency problem. Right? Poor money management. Maybe you want to set up a trust and make sure it lasts as long as possible. For like a guardianship, I know I had a will set up recently because we wanted to make sure we got to pick who Henry went to, right? It's also like in charities and associations. A lot of people, if they don't have anyone, or they'll give half to like their family, and they'll give half to a charity they've loved all their life. When people are having like less and less kids nowadays, and you start to see pet trusts, right? They want to leave the house to the pet, and then they have someone come in. So the trust will pay for people to come in and feed the dog and all that stuff. And then basically when the pet passes away, well, then the trust will like sell the house, and the money will go to like their favorite association. Another reason we've kind of talked about this one a little bit is people start their estate planning is to avoid taxes. I kind of included this map because I thought it was interesting. The red highlighted states are states with an estate tax, and then the green states are states with an inheritance tax. So I just thought it was interesting because I didn't realize Iowa and Nebraska, we had some neighbors that had it, but really the difference between there is like the estate tax. When you pass away, everything goes into your estate, tax is paid at that point, and then the assets are distributed out to the beneficiaries tax-free to them. Inheritance kind of pushes the burden onto the heirs, whereas they're the ones paying the tax. So that's what that was kind of. And again, like Jonathan talked about too, like irrevocable trust, there's plenty of tax planning strategies that usually do with trusts and with beneficiary designations. So there's like gifting strategies to avoid a lot of that if you do it soon enough. So. Another reason is the desire to avoid probate. CJ already talked about it a little bit, but basically it's pretty expensive, especially when you're intestate, right? When you have no will, it's a much longer process. It's a lot. I mean, it's just a long process, months and months and months. And during that time, assets that go to probate are frozen. So you have absolutely no access to that until the process. And while you're waiting for months and months and months, right, depending on your family situation, there's usually bickering family in there, right? In this kind of political climate, right, there's a huge distrust of attorneys and courts and things like that. And there's just an overall like basic misunderstanding of the probate process. Getting your estate in order and avoiding some of these issues like probate can actually save your family quite a bit of headache. I threw this in here. CG again talked about it a little bit, but this is actually what happens if you die intestate. So let's say I pass away and my spouse, I have no spouse. And the first level, it kind of goes in brackets, but the first level is to kind of go down your descendants list. It'll go to my children and my grandchildren. After that, it kind of goes back up the family tree and it'll go back to your parents. And if your parents passed away, then it goes to your siblings and then down kind of down their family tree. And if you don't have any siblings, well, then it actually goes even farther up the family tree, goes back to your grandparents, and it'll go to their kids, so your uncles and aunts, and then so on and so forth. So I just thought it was interesting because like a lot of you guys are younger, but you'll be getting like pretty soon, like maybe your first homes and things like that, right? Let's say you want it to go to one of your siblings. If you don't have a transfer of death on your home, if you don't have it designated in your will that you want it to go to that sibling, it's going to your parents. So just some. This one I'm not too familiar with, but a lot of it kind of seems to creep up more and more is I want to protect my estate if I get sick. And this deals more around the idea of long-term care expenses. They want to pass something on to their loved ones, but if you have long-term care expenses, it's thousands and thousands of dollars a month, depending on what kind of problems you have. And there are some strategies, but you need to kind of do it early. There's like a 5-year look back for things, so you can't gift too soon to you getting sick because it'll be clawed back in. The idea is the way it works is there's kind of like assets that are considered countable. There are assets that are considered non-countable. And you are required to spend down those countable assets before Medicaid will kick in and help you manage the expenses for your long-term care. So. Kind of all right, so in summary, while you're doing these things, there's actually gonna be a lot of hard conversation. Like, again, for like a personal example, because these are easier for me to explain. My wife and I are incredibly on the same page. Finances, how to raise Henry, everything. We came into one of the most adversarial conversations we've ever had in dealing with who gets Henry. We had like 5 super great options to pass him on to, so which something were to happen to both of us. But it ended up coming down to she had one from her side of the family that was a great option, and I had one on my side. My sister and my brother. I was afraid that basically he was going to get estranged from my family because her side is super gung-ho. They have every weekend planned out. They're constantly gone. I was worried that basically he'd be gone all the time. It's super hard to access. Her brother is farther away from the family members, and that basically he wouldn't get to see my family much. And I was like, well, my side's closer. My sister has, trauma training. I'm guessing there's gonna be something wrong with them. Both of us mysteriously disappear. It just there's a lot of you don't actually run into. It's crazy how many problems you run into when you start going through the process, and it's better to do it now when you have the time than when you pass away and you have to have someone else do it for you. I did actually. It was the trauma. My wife's a mental health therapist. So she's like, yeah, she loves the idea. So, well, if we were to pass away, silver lining kind of thing. Well, just like some aspects of this, the point of estate planning is to kind of do the work now to prevent your family from having to do it when they are arguably one of one of the toughest spots in their life, right? Like, and even when everyone wants the best for you and they would do what you would have wanted. Everyone has a different idea of what that would be, right? It's like the best person to make these decisions is you. And the sooner you put in the work to ensure that these objectives are met for yourself, like the sooner you can have the peace of mind that when you pass, that your family will be protected and that you're basically like your will go according to plan. So.
Real quick. So that some of the numbers in here were a little bit off for inflation wise, right? They're almost always adjusted for inflation. Make sure you look those up, like the state exclusion. Another thing to put, yeah, sure. Oh, the 2023 figures have already come out, so that's good to know. Yeah. Okay, yeah, big jumps for the inflation. It's also important to know in the historical context that the federal estate exclusion right now is at 11.7 million. That's set to expire to about half in just a couple of years, 2025, if nothing changes. So a lot of this stuff will become quite a bit more relevant tax-wise in just a couple of years. A lot of those people who would either need to give or do gifts to use up that exclusion, or they're going to lose it or die. Right, a lot of things can happen. So. But yeah, I think that covers it. So if anyone has any questions, we can respond. Otherwise. Okay.
Not really a question, but more of a comment, and it's kind of going back to Chris K sharing his personal experiences. These are often decisions that you want to also discuss with the people you plan on putting in charge of kids or money also ahead of time. You want to make sure they're willing.
We had problems with when we were initially trying to get our will set. We had everything finally finalized with the two of us. It took us another 2 months because Melissa didn't want to tell her brother that he was second choice to defend it. So she had to build up this, she had like all this anxiety and she couldn't do it, right? And eventually like, I'll do it. She's like, no, I'll do it. Fine. And then it was like a 2-minute conversation. Oh yeah, that's fine. Well, sure, we'll take him. If the other, it was like 30 seconds on his part and he was done. And she's like, well, what the, you know, and she was worried about this for like 2 months. And like, I mean, not that our families would have fought, but I feel like if my side definitely would have, right? 2 of them. And I feel like both her side would have wanted them too. And like, even though like Henry had all these great options, there's still been like infighting because everyone would have been fighting. It's better for you to make those decisions than having other people do it for you. The problems grow exponentially when it's people deciding it for you.
Yes, Todd.
Chris, what I like what you're talking about is that state planning is the right asset to the right person at the right time. The right asset to the right person at the right time. It has nothing to do with taxes. We can help make it more tax efficient, but that's not the purpose. So whether you've got family heirloom hair plate that you want to make sure goes to a special person, if you don't write it down, it will not happen. That was the whole deal. My brother, he had written down what he wanted, but he didn't have the balls to have an attorney actually write it up. So he thought he would die if he actually wrote it down, and then he died. So nothing happened. Nothing happened the way he wanted, even though it was all written down, even though he had a brother after him for years to get it done. So it doesn't have to be about dollars. It could be about that special plate. And the kids is a huge deal. I'm glad you talked about that, Chris, because you know about who your family should go to, or you believe you do, and well, then make it known, because otherwise you're putting the stress on the two. So, oh, who's going to do it? No, if you made the decision, removes all that burden from there. When you're the other thing is when you are looking at tax and the tax rates, remember that you've used up all the low rates, almost all the low rates when you're going through that exemption. So the Minnesota tax rate really starts at 13% if you have a taxable estate. And the federal tax rate is 40% if you have a taxable estate. And if you need some incentive to help people move forward, if you cross that $3 million barrier, you have to do a whole federal tax return, a state return. State return is just a balance sheet, right? You have to do your balance sheet, list all your assets and pull it together. You're looking at $15,000 at least to pull it together. It's a pain in the tush form, very logical, the most logical tax form that's out there. But it is a royal pain in the tush to put together. So you want to work with people to make sure that things are happening the right way at the right time and going to the right person. So that impacts everybody here, whether you've got kids, whether you're married, doesn't make, and however young you are. I mean, Kyla's at a funeral today for a 14-year-old. You don't know what a sample of one is not a sample. You don't know when you're going to die. So yes, it's a pain in the tush, but it's better that you sit down and do it, knowing that you can change it every Thursday if you want, but do something. So at least you get it 90% right. Otherwise, you have a will all drafted from the state of Minnesota. And for those of you that may have been on a second marriages, how would you like stuff to go to your ex-spouse? You don't do things right.
Always check your beneficiary every couple of years and after any kind of major life event. Because even if you have like in your will, like a 401k, if you have your ex-wife as a beneficiary designation on that thing, the designation will supersede the will. Go with that. And it kind of brought to my attention that you should check it every time let's say like you have life insurance or a policy like that, if it switches companies, sometimes beneficiary designations will get wiped. So you might think all right, this is definitely not going to probate. Well, life insurance got switched to a different company, the beneficiary designation will be transferred over and now it's going to your state. And now it's stuck.
Any more questions, or does Cindy want to add something?
And the power of attorney, the importance of it. Just in my own life experience over the last summer, I had 4.5 months of my mother being sick. And I had that thing out every single day. So I could take care of her health needs. I was able to get her into a nursing home. I was able to do all the things because she couldn't do it anymore. And it's important to make sure it doesn't matter, like Todd was saying, it doesn't matter how old you are. I mean, you want to have it for your parents. If something happens to your parents, do they have something in place? As I know how hard that conversation is to have with them, but it's important to know if they have something. So just in case. I mean, I do that for my own kids. They're in their 30s. If something happens to me, they know, okay, I have power of attorney. I have a healthcare directive. They know where it is. My wishes. It's really important to have those conversations with your spouse, with your parents, with your kids, everything.
Great way to start those conversations. Start with your book. So these are available. You see them around, but if you have a client or a family member, just let me know and I'll send it to them. And then the other handout, this reference guide, I've sent this to a lot of contacts, family, friends, clients who lose a loved one and kind of use that as a checklist to help delegate stuff out to other people because they're like, what do I do now? So these are also on our website. There's an electronic version of this on our website. This niche group has tons of resources if you're looking for somebody to help you with a will or get your healthcare directive. That's what I did too. I'm not an accountant, so I don't know all that stuff. So I just asked people, who do you think would be a good match for me? And so I use mindful asset planning and they're great. So just know that they're out there for a resource too, for you and for your clients. And if you run across an organizer coming up where you see somebody has passed,
Things you can potentially look for that might become applicable to us. So if you have a new client, you see something about a trust, flag down. In the organizer, it will also say something about further. Thing really we talked about today that you're not then Cindy's a good resource to go to, or any of us. Well, looks like Terry's got a question.
Quick one. So beneficiaries on bank accounts. So versus like transfer on death or being joint on the account. So if there's a beneficiary in the bank account, that doesn't have to go through probate. So I'm assuming that's a lot quicker to get the cash. I mean, like as soon as the person dies, can you go in with the death certificate and say, hey, on the transfer account, and or is it?
Right. If it's a TOD or a POD, if it's paid on death or transferable on death, and those are specific designations on that account, then yes, that's the fastest way to get it. Never needs to go through probate. Oh, that's definitely gonna be the fastest way to get that cash, yes. And we also want like IRAs and things, anything that can be put in that designation, it's generally a good idea to get it in that designation because it's the fastest and quickest way and most secure, I suppose.
And then then just a follow-up question. You kind of touched a little bit about blended families. So when you go through that line, I'm assuming that like, you know, you have a married couple and they each have children from previous marriages. And so in that case, it's kind of like the kids of the first one to die, so to speak, is kind of SOL if there's no. Right.
We're ready for you.
Oh, sorry, I couldn't hear for a minute. I was just going to mention that I did this stuff recently, and it's a benefit through our ease package. So if you don't have a will or these healthcare directives or power of attorney, you might want to sign up for that this next benefit period, get it taken care of, and it's very reasonably priced, and it was a really efficient way to do it. So I just wanted to throw that in there.
How does one go about getting TOD designations on their financial accounts?
A lot of them, if they have online portals, you can complete it online. I did recently with my own IRA. It will say select your beneficiary, and it will say this is now a transfer on death or payable on death account specifically, versus just putting beneficiaries to it. Or I'm sure you could also, call the teller. But if Cindy or Todd have another way of designating, but I would just look for those terms, TOD or POD, payable on death or transfer on death.
Go to the bank and they'll just tell them, I wanted this to change over to TOD. I did it on all my investment accounts. Just called my investment advisor, said, I want these TOD. She sent me a form. I signed it and it was done. Who do you want as a TOD? It's a little bit more problematic with real estate. When I did my house, I transferred TOD to my 2 kids. And I went through an attorney to do that. It cost me about $350 to file, to change over the titling on the house. But I did that to make sure it went directly to my kids rather than having to go, because I only have a will. I don't have a trust. So I just wanted it to make sure everything went straight to them. So trying to avoid probate by going over the will and making sure everything I have is either TOD or designated beneficiary, such as an IRA. My insurance is designated beneficiary to my kids. And just to make sure it can't ever go to somebody I don't want it to go to.
Extra thing for you to do if you want to update your will, you need to also think, oh, I also need to update my TOD accounts, because those will not be updated with your will, as we said earlier.
Just directly to the person, like it would go, like if you wanted to go to your kids, to your wife, Well, then, you know,
Like if my wife is gone, there isn't a secondary.
that would be something you would have to talk to the bank about. I mean, it's in your will. No, I mean, you have it for your IRA, you have your initial, and then you have your contingent, right? So as far as a TOD, I mean, I only have my kids. They're not. So as far as you say you want TOD to your spouse, I think with a spouse, it's a little bit different. You can have it titled a little bit differently. I know that with my mom, I didn't have a TOD. I had an account, we weren't joint. We were both named on the account. So when she passed away, it just automatically went to me, but not as a TOD. So.
Hey, Frank, that's where you use revocable or living trusts. Because like my investment account it's in the name of the trust, and then the trust then can have all that flexibility in there. If my spouse doesn't live for an additional 60 days after death, all the fancy language can be in there. And you can special if at what's, because that way is a way for you to lay out what you want to have happen and the way you'd like it to have happen, but still keep it private.
About revocable trusts, if you have one, make sure you actually title your assets in that trust. We have a lot of clients say, I have a revocable trust, but all of their assets are titled in their name still. They never go through that process of actually changing the title, like of a house or, you know, I mean, from my personal example, my mother died. I don't have to go to a lawyer. Everything is titled either in my name or in her trust. I'm the trustee. Everything just rolls over. It's easy. It just, you know, I have no issues with, I don't have to hire another lawyer or do anything. It makes it much easier for me. It makes it easier for the beneficiaries. It makes it easier for managing the estate. And it makes it easier for everybody involved if you plan in advance.
Mark said in the chat that the gift exclusion is going up again in 2023 to 17,000. So last year it was 15,000. This year it's 16,000. Next year it's 17, just because inflation is up so fast. So always good to just check those inflationary numbers before you just go with something. Coming.